Okay, today we are going to read about the most active law in India. This law has been used enormous time. It is the most active law in India which was used by everyone. Okay, it is none other than our RTI Act. Even a census has told that if beat any law for time being, be it IPC or anything, RTI is the most used act, it seems, in India. Now, although it is a very famous act, it is very active one. Now, our concern is whether many questions appear from that for UPSC law optional because we want marks, right? So, how it is relevant to our examination UPSC law optional. But the sad thing is, it is one of the least asked topics in UPSC law optional. You may think that why are you telling this, ma'am? Because see, it is our duty to tell when it is very important. At the same time, it is our duty to tell when it is not important as well. So it is one of the least asked area. Now the next question comes. Whether you can ditch this area, for that I will show you a very important area now, which is previous year question. So you will know whether we can skip or not. Hope this is visible to you. Now check 2025, there is a question. Recent 2024, there is a question. 2023, there is a question. It was not asked in 2022, 2021, it was asked. 2020, it was asked. So if you scroll down from 2019, it was asked like that. Okay, but when we compare to other topics, we have least number of questions in previous 25 years. But nowadays, UPSC is very fond of RTI Act. So repeatedly they are asking question nowadays. So you have to understand there are specific areas in UPSC which will be asked traditionally. Traditionally, it will be repeated. Example, murder and culpable homicide, traditionally important topic. It will be always asked, even in your semester, like that. But there are certain areas which will gain importance nowadays. Okay, if you are preparing for judicial service, the punishment areas under the IPC and BNS is gaining importance nowadays, and they are asking a lot of questions. Like that, RTI has gained importance nowadays, and a lot of question is asked since 2023, 2024, 2025. So there are good chances it can appear in your upcoming mains. So we should not ditch this topic. So welcome to Lawxpertsmv India. Today we are going to decipher RTI Act, a 17-year law which has 16 million active participants. That is 16 million have, I'm sorry, 6 million have used this act like that. Okay, it is very useful for what? For creating transparency. How transparency is achieved? What is the history of this act? All that we are going to deal now. Okay, once next half an hour, if you're going to listen, any question which was asked in the past in UPSC law optional means from RTA, and also anything that is going to appear in future, you'll be able to answer everything. Okay, now we are talking about right to information. So whether this part called as information, whether that is something new to us, it was introduced only from the RTI Act. No, the Constitution per se talks about deciphering certain important information. We know everybody will be talking about Article 19, Clause 1, Clause A. But before that, we have to think other areas as well, where the Constitution says you have to give certain information, because information is wealth, information is everything. You will understand when I quote you the article. Look at this article, Article 22, Clause 1. Any person is arrested. While arrest, you have to give him the reason for arrest, the grounds for arrest. Even in preventive detention arrest, that is, you are being arrested for preventive detention laws, that arrest also you have to inform the grounds of arrest unless and until it is not prohibited for the public good. Okay, so when you are arrested, they must give you the information regarding the grounds of arrest. See, that information is very important for you to safeguard yourself from remand, safeguard yourself to get bail, and all those stuff, right? So, information is giving you some right. You access the information so you can get some solid right. So, Article 22 is right there. And once you become a servant, civil servant, now whether you can be removed without giving any reason, see, not anything negative. I'm just letting you know that's it. Okay, you won't be removed. You'll all be in service till the end of your service term. No worries. Okay, just asking. So, if you are in service, whether they can remove a civil servant without giving any reason, that cannot be done because you have a protection under Article 311, Clause 2, which is an important area for UPSC law optional means. Again, we will be reading that when we are reading constitutional law. Okay, so 311, Clause 2 says that any dismissal or removal of a civil servant, you have to give the information and reason regarding why he is removed. Like that. Okay, so information, giving information is a mandate in constitutional law itself. And also, this Right to Information Act played an important role during COVID situation. They were talking about like a lot of informations were filed, seeking informations were filed for getting access to public health and all those stuff, medicines, and also funds were allocated for any. See, a lot of children lost their parents, and a lot of frontline workers were affected by corona, and they in turn died. Okay, so what is the relief given to those people? An RTA was filed, and they got a lot of benefits, welfare schemes because of the RTI. Okay, so this is all importance of RTI. So where do you link this right to information? We link it to Article 19(1)(a). You all very well know 19(1)(a) talks about freedom of speech and expression. See, right to information. What link it has with your freedom of speech and expression? You can ask me. But think one small thing, that is our mother or my grandmother will not talk against my grandfather or my father. Okay, like that. Whatever they say, even if it is wrong, most of the times or sometimes, they will say, yes, I will follow it. But today, if my husband is going to abuse me, he won't, but just letting you know. Okay. So if somebody is going to abuse me or giving me some wrong advice, I won't be quiet. I'll talk back, right? Why I'm able to do that? Most of the women today are able to do that. Why? Because we know certain informations. We gain knowledge. We know that somebody is oppressing us, and we have the right not to be oppressed. Right. So how do we get that? We have this expression. We can express. We can speak only when we get the information. You can write a very good answer. That is your expression, right? Very good answer in your UPSC. Oh, when you can write a very good answer, whether you can write stories, no. When you can do that, only you read well, only you get the information. You can express yourself. Yes, that's why we say your right to information is a part of freedom of speech and expression. Simply for this, that is, only you know something, you will be able to express yourself. Okay, so this you can use for your introduction. 1 second, I'm getting certain messages. Yeah, recent AIB also there was a question. Thank you so much. Yes, yes, this relationship between your right to freedom of speech and your right to information is a very important one. It was linked in two important case laws. We will see the case laws as well. Now, coming to the next slide, we all think that this right to information is a statehood, that is, it belongs to a particular country, that is, from India, it is, whether it has any international support or what. Yes, in 1947 itself, in General Assembly in United Nations, they declared that freedom of information to be a fundamental human right. Yes, in India, we declared that to be a fundamental right. Whether it is a fundamental human right, exactly, it is a fundamental human right. In 1947, GA, that is General Assembly United Nations, declared it to be a human right. Okay. And it also said that it is a touchstone for all other liberties. You check, you have a lot of freedoms under Article 19. Freedom to trade, freedom to do business, freedom to settle down in any place in India, form associations and all those stuff, even right to life. If anybody to realize that he has right to life, to protect it, what he must know, he must have the information that he has certain rights, right? So right to information becomes the basis for enjoying all liberties. Only when you are informed, you know you have all types of liberties. That's it. Okay, that's what that was pointed out here. And also there was a separate conference held I'm sorry, by 1948 or by United Nations, which is called as Conference on Freedom of Information. This was held in Geneva. You can talk about this as well. And also, see, right to information may not be a very important right in a dictatorship. If you go to North Korea and say, right, I have right to information, so Kim Moon Jung must tell me that how he is appropriating the funds for the government and all. If you say that, you are dead. So in dictatorship, we cannot ask for such rights. But in democracy, right to freedom of information is very, very crucial. That's why I have brought an international definition linked to democracy. So Thomas Jefferson's definition is very, very important. You can use these points for your introduction, for your 15 marker. It will be very suitable, or even for your 20 marker if it is asked. Okay. So information is the currency of democracy and critical to the emergence and development of a vibrant civil society. So, if you want people to be part of the governance, that is like they must see the government of the people for the people, right? So, the entire government runs for the people. If any agency is running for me, I will have all right to know what this agency have done, what the agency is doing, what is its function. So that's why this right to information is the currency of democracy, and also it develops a vibrant civil society. Okay. Now it is also recognized under Universal Declaration of Human Rights, International Convention of Economic, Social and Cultural Rights, and we need a forerunner, right? Like a first state or first nation state, I'm talking about, not Indian state, a first country to realize these freedoms, freedom of press or freedom of information. Freedom of information is closely related to freedom of press. Only when the press has freedoms, it will decipher a lot of information and you will be knowing those information. And under these acts itself, like Freedom of Press Act, there'll be an option to get information from government agencies as well. So Riksdag was the first to give you this right, which is none other than the Swedish parliament. So it was Sweden, the first country to recognize your freedom of information, which is under the Freedom of Press Act of 1766. Okay. See, internationally it was recognized in 1947. This Sweden already recognized in 1766 itself. Okay. So you can talk about this as well in your introduction and also in conclusion. Now, coming to International Covenant on Civil and Political Rights, if you're talking about that, Article 19 is the related provision. It says that everyone, everyone in the world has freedom of opinion, and this freedom of opinion is related to freedom to get seek information. So it gives the two sides of the same coin. See, everyone can give freedom of opinion. When you can give opinion on something. If you don't know anything, whether you can give an opinion, but in Indian society, even without knowing something, we will be giving opinion. We don't know about others' life. Simply, we will come and say that no, she's not doing well. She's not taking care of the child. She's not working. She's not doing anything. Everybody will say that without knowing anything. But to be truthful, only when you know the information, you can give an opinion. So you do have right to freedom of opinion. To enjoy this right to freedom of opinion, what you need to seek, receive, and import information and ideas. So, right to freedom of information is pinned under Article 19 of your International Covenant of Civil and Political Rights. See, most of the aspirants call me and ask, how do I give an introduction? For you only, I'm giving all these points. These points are very important for your introduction. Instead of giving a boring, common introduction, you can use above 3 slides. You have to first say where in constitution and all information is given. And where do you link with Article 19 Clause 1A? And it has been widely used in COVID situations and also international relevance. And then you come to the landmark case law. I told you 2 case laws have rightly pointed out that your right to information is a fundamental right under Article 19 Clause 1A. It was given in Bennett Coleman case, very, very important case. When we are doing 19 Clause 1A, this case law is very, very important. Okay, so Bennett Coleman case and also in Raj Narayan versus State of UP. This case, again, they pointed out your right to information is a part of your freedom of speech under 19 clause 1A. Okay, so these two you have to know. Next, you have Raj Narayan case. Again, a famous case law. Nobody can forget this case law. So in Raj Narayan case, the court told that, see, the government cannot work under the veil of secrecy. It cannot work under the secrecy. It has to be transparent. And the common business routine must be explained by the officials to the public. So, inside a small wheel, entire government cannot operate. The officers have an responsibility to explain what happens. So, once you are appointed to your concerned department, there will be a PIO elevated from your department. And whatever you do in your department, we have all right to send RTI and know all the information. Okay, so that's what it is. Now coming to SP Gupta case, it has been same thing repeated. Any 2 case laws, if you know and you're able to retrieve that, that is totally enough. And this case law, Raj Narayan case law, is very important. So it is not negotiable to omit these 2 case laws. Okay. Now coming to SP Gupta case, the right of people, actually the people has the right to know about every public act. That was the explanation it was given. So, if a question appears on RTI, right to information, is for the transparency and accountability of the government, then you can quote this SP Gupta's case. Very, very important one. Okay. So, we have seen the Rajnarayan. Now, earlier, did we have this Right to Information Act? No. The agitation, the demand for right to information started only in 1990 in India. They had this Sabha called as Mazdoor Kisan Shakti Sangha then, which was formed by rural people of Rajasthan, and they were like wanted to do an audit in their government spending in that particular local area. Okay, they thought that it is not spent properly, so they started a small movement and wanted the government department to be transparent and to give responsible accounting for their work. Like that it started, and then it started as a national campaign for people's right to information. And with all these campaigns, they wanted to know about food security, shelter, environmental troubles, employment details, and other survival needs also were questioned. See, we never knew. We have the state public service commissions, and they say so much of vacancies are there. They conduct an examination, and randomly some people are picked, some are not picked. They say we have examination and they don't conduct the examination at all. So all these problems were involved, and everybody started to question, see what you are doing, we need the information. Like that, they started to question. So when the campaigns grew very hard, we had a special law in place. But before that, everybody knows that we got a act. But before that, you have to know there have been certain acts which was asked by, like, which asked the government to be quiet. Certain informations, certain things, if anybody asks, the government should not give. You should be quiet, although it is asked by the people. You are a government, you are responsible, you are a welfare state, you have to give, but you shall not give in these situations. So one time, one area, that is one side, in 1990, people wanted certain information. But these acts stood in the way and told that, no, we can't give you information. So important sections for that against our information, Right to Information Act is especially section 123 of our Indian Evidence Act. It is also retained now in today's BSA. Okay, it says that any unpublished official records cannot be released by any official unless and until they get the permission from the higher authority, head of that department. See, some important or some fishy thing is done by a department. They will put an order, yes, but they will not publish it. They will keep it. Once when it is published only, it gains importance. But they will publish in such a way that it is not known to others. Okay, like that they will do, and they will keep it as a secret. Now, if that involves any corruption charges or something, the court will need that particular document. Whether the court can ask that document, no, it is precluded by 123. It says that any unpublished official records cannot be asked. Even when the court needs, it cannot be asked. And it can be sought only from the permission of the head of the department. Whether the head of the department who is involved in the corruption as well, whether he will give permission to give that document, he will not give. So see how they are protecting. Okay, with the law itself, legally, they are protecting certain wrongs. Okay, that is one thing. Next, we have our most infamous Official Secrets Act. It has a list of things where public servants cannot disclose. Okay, that's very important. And you have Rule 11 of the Civil Services Conduct Rules, which will be binding you once you become civil servants. So, no civil servant, except with the order of the government, in good faith, can give the official document. If your entire department is doing something and the government says that you don't give, even if it is wrong, if you become a whistleblower, it will be a legal problem under rule number 11. Okay, again, oath by a public servant. Yes, when you take your oath before joining the duty, you will swear that you will keep the information secrets of the state. See, if your information is going to protect the state for the welfare of the people, then that is totally fine. That's why we have this oath. But even this is used against whistleblowers sometimes. That's why we got the Whistleblowers Act at the later point of time. We will deal about that at the later time and at the end of the slide. Okay. And then we have this resolution policy under which was passed in 1972, which says that unclassified and classified information. If it is an unclassified information, even if it is important for a court or something, without the government permission, you cannot tell it out. So, although there was a widespread agitation for right to information, all these acts were present to make the government officials keep them mum, keep the secret. Okay, these acts were there. So if you mention just the names of these acts and say that they were keeping, they were asked to keep certain documents quiet, or it was against right to information or something, that will give added points to your answer. Okay, now coming to the point, although you see there are a lot of acts which were protecting the secrecy, there was a lot of agitation. So said they wanted to bring a balance. They wanted to protect something which is very serious. See, now I cannot go and ask government, put an RTI and ask like, what is your, where do you have all those atomic energy stored? Exactly which area? What is the secret vault in our ISRO where we can access? It is protected by password. Can you give the password? Like that, I cannot ask. So certain things are secret. They want to save the secret as well as they wanted to bring the accountability, transparency. So that's why we got our first Freedom of Information Act 2002. It is not our RTI. This is the mother of RTI. So even before RTI Act, we got this act called as Freedom of Information Act 2002. Okay, so this act is a huge failure. The main reason is that it gave just a freedom. You see the heading? It goes like this: Freedom of Information Act of 2002. It did not make any right to information. It did not give any right. It just told everybody have freedom to get information. That's all. Okay. Did not give specific provision. It's a right, a strong right. And if anything is wrong while seeking the information, there was a redressal mechanism, appeal mechanism within the government bodies. The court was barred from the jurisdiction. So even though the department is not giving any information, they are keeping it for from 2 years, 3 years, they are not giving at all. Still, you cannot approach the court. That was the thing. So the department is doing something fishy and you put a letter seeking information from the department, whether the department will give you the information, they're not going to give, definitely not going to give. And still, what we have to do, we file the appeal in the same department, and again the redress and all the redressal mechanism, we can have it only in the department. We cannot go outside of that. What they will do, they will keep it even, bury it even harder. So whether this act was useful, it was not at all useful. That's why this act was scrapped away by our Right to Information Act of 2005. So, what was the new addition that was brought in the Right to Information Act of 2005? The first edition, which is the machinery for investigating powers. That is, see, you can challenge the decisions of public information officers. That is, you will go for an appeal and you can go for a second appeal, and you have a separate commission, information commissions, which was established, state commissions, national commissions was established even to levy penalty against these officers. Okay, so that was the thing. So the mechanism, investigating powers and challenging the decision of PIO was strictly brought in. And then penal provisions was also inserted in case the public information officer did not provide a proper information. Okay, see, there is a saying in our state, that is in Tamil Nadu, they will say that even your sister or brother will not help you like a slap will help you more, it seems. Okay, so if you tell someone to work properly, do these things, they're not going to do that unless and until you pin them with a penal provision. That was done in your RTA Act. And next, it also provided effective mechanisms for access of information. It was backed up by constitutional provisions. All these things you will understand when we decipher the act. Okay, so these were the additions. Now, when we come to Right to Information Act, it had important objectives. What are the objectives of Information Act? Or whether the objectives of the Information Act have been achieved. If these questions are asked, you must talk about its objectives. Okay. So its primary aim was to promote transparency, create accountability in the functioning of all the public authorities. So how do we create a transparent environment? Only when we ask questions, we will actually get things done. Okay, that is the thing. I don't know how far people ask questions, and if someone is very actively ask questions, whether they are safe or what, That also we will do a reality check at the end of the session. But theoretically, getting marks, what is the aim of this right to information? It is to promote transparency, create accountability, create an accountability on what? Functioning of the public authorities. That you must be able to write. Okay. Next, you have 6 chapters and 2 schedules under this act. Your first chapter deals with the basic things like the name of the act preliminary part, and then it gives the definition. We have an important definition. What is the definition of information? So we'll do that as well. And then what is the scope and extent of the act? Yes, today it applies even to Jammu and Kashmir. You all very well know about that. We had this reorganization act and all. So it applies to Jammu and Kashmir as well. Now, coming to the second chapter, it deals with a right to information. Yes, you have right to information, but how do you get that? What is the procedure? Okay, that is given here. And the corresponding obligation of the public authorities to maintain the information. So this chapter 2 is very, very important. Certain definitions are important, and chapter 2 is very, very important. Next, coming to chapter 3 and 4, it talks about state and central information commissions. And then chapter 5 talks about powers and functions of these commissions, appeals and penalties, which is again very, very important. So what is important? That's what we are going to cover here. So no worries. You after just 30 minutes, you will be able to answer most of the questions. So coming to the definition part. 2 clause F gives you the definition of information. So what is information? It is a very big inclusive definition. It says that any material in any form is an information. Any material be the point. In any form it can be. That is called as an information, including what? It can be some records, it can be a document, it can be a memo, it can even be an email or an opinion, advice, a press release, circulars, orders, logbooks, contracts, reports, papers, samples, models, data materials held in any form, including electronic form. Okay, like floppies, diskette, everything. So, what is basically an information? It is any material in any form, which includes all these lists. Okay, and finally, you can ask a question whether information about a private body that comes under the whether this private body comes under the purview of information. We all think that only a public authority will come under the purview of the RTI Act, but no, it is a big no. We have a small area of exception, that is any information relating to a private body, but it can be accessed by the public authority. So it is the information concerning a private body. You cannot put an RTI to private body, but what you can do, this is the information pertaining to private body, but this information is accessible by some public authority. Then you can put an RTI to that particular public authority and get the information. Okay, so any private body which information is accessible by the public authority is also an information under the RTI Act. You can ask me to give an example. Right now, we have an example which is called as a Sterling case. We all know about the toll gates, right? We have a lot of toll gates. We do pay a lot of toll. If I go to court and come back, I would be paying 2 tolls. Okay, that's how it is. Because highways are very easy to access from my home, so I do that. Okay, now these toll gates, whether they are maintained by the government, no, it is by the private bodies. So it is like public and private partnership. With that, they are having the tolls. So if at all I want to get any information about these tolls, yes, the information of these tolls will be with the public authority, National Highway Authority. So I can put an RTI and get information about these tolls. These tolls are private body, but its information is accessible by a public authority. So I can put an RTI. Okay, this was held in the famous Sterling case. You can note this case. It will add a lot of marks to your answer. Okay. Now, Seri, okay, there is a lot of informations. I know. From where I can get the information? You can get the information only from the public authority. Whether you can put an RTA to me and get an information, no. But once you clear, I can put an RTA and get information from you. Okay. So public authorities are only coming under the purview of the RTA. So who is the public authority? That is the next question. So let me tell you, public authority is any authority, body, or even an institution of even a self-government. But what is the condition? It must be established or constituted under the constitution. Like I can put an RTA to Supreme Court. I can do it to the High Court. Yes, I can do it. Okay. And next, by the constitution or by any law made by the parliament. Parliament is making any law, creating an authority. I can put an RTA to it. Or it is made by any state legislature. I can put an RTA to it. Or at least by notification of appropriate government. If such government is creating any public authority by only notification, no need of law, just notification is given by the government and authorities created, still it is a public authority. Okay, and it includes any body owned, controlled, substantially financed by the even non-governmental organizations, substantially financed directly or indirectly by the appropriate government. So this public authority has something closely related with the definition of state under Article 12. So interesting case in this is the BCCI case. They told that BCCI everybody knows, right? Because everybody watches cricket and BCCI. See, BCCI is an NGO, it seems. Sorry, it is a non-governmental organization, and it is it is a non-profit organization, something like that. Okay. So they need not pay much tax and all those things. If I talk about that, that will be bad. So let me jump to the point. That is BCCI, which is representing India in cricket. Most of the countries identify us by cricket. And they say that BCCI is not a state under Article 12. But it comes under the purview of this public authorities under the RTA. That was the judgment given. That you can note one thing. Next question is whether political parties come under the purview of RTA. What is your answer? Whether political parties, they are not running the government, just political parties, whether they come under the purview of RTA. This was a huge tussle. You must have known about it. You people are preparing for UPSC. No idea? What, Soumya? Tell
Yes,
me, please.
ma'am.
They come under the purview of RTA?
Yes, ma'am.
How, sir? Supreme Court gave the verdict?
Recently, CIC has ruled out, ma'am. Central Information.
Not recently, in 2019, sir.
Yes.
Actually, it was, yes, you are right, sir. Exactly. Good answer. So initially, they were having a lot of problems. Political parties, how you can bring us inside RTA? Then you will ask what all funds we received and how we are appropriating the funds and all those stuff, right? They were so panicking and they were having a tussle. And finally, I have brought the entire tussle. It will be very interesting. So it is right here, the timeline I have brought. And what happened finally? Your Central Information Commission in 2020 ruled that political parties come under the purview of public authorities. And this decision of Central Information Commission was challenged in Supreme Court and it is still pending. Since it is pending, the verdict of your Central Information Commission is final as of now. So today I can put an RTA to the political parties. Okay, that is like the Supreme Court is like giving only dates. And I think the hearing came in April or something like that. After that, it did not come. Okay. So let it go like that itself. CCI's judgment is very good. So let it be just like that. So typically talking in today's world, your today's time, political parties is a part of your public authorities. Now coming to the point whether Chief Justice of India come under the purview of your RTI, yes, he does comes. And you can put an RTA to him. And whether Prime Minister's office PMO comes in, of course, it is again a public authority. And this was not achieved easily. We had a lot of tussles, and it is there given at the end of the slide. You can read when you have time. Okay. So now coming to the important area, right to information. So you can define information. You can say who's a public authority, from where I can get the information. Next point is what right I have. What is right to information? Yes, a right to information is accessible under the Act, which is held under the control of the public authorities. So this is the link. They have defined what is information. They have defined what is who is a public authority. Now, how do you relate it? What is right to information? Yes, you can have the right to information, not from a private person. Nobody can put an RTA to me and ask, like, see how much you earn. What do you do apart from income tax? Okay, ask me all these stuffs. Where do you went last night or something like that? They cannot ask me like that. What is the connecting link between this information, definition information, and definition of public authority? Your right to information. You have right to information only against the information which is under the control of the public authority. And not only getting the information, it is like a bundle of rights. See, copyrights, we say it is a bundle of rights, right? Like that, right to information is also a bundle of rights. What all rights it includes? You can inspect the work, documents, records, and all. Yes, it is not that RTI you can only file an application like in paper, you have to send it and then you get it. For the purpose of records purpose, we do advocate send it in like papers and all. Whether you can jump into a government department and ask where is the public information officer, go right there and you can ask and get the information, inspect the record there itself. Whether you can do it, yes, you can do it. Okay, so you can go inspect the work, documents, and records. You can take notes, extract certified copies, and all. You can take separate samples of the material. Once I have to visit my uncle or someone. Okay, he is in one secretariat department. He is working there. So what my father did, they are very close. So once he picked me up and we all went there and we told we want to meet the, it is an abuse of Right to Information Act. I do agree with that. And we went to the department and we wanted to meet the PIO, and he is the PIO actually. So we went there and met him and told we want to see some records, and he was amused actually. So the thing is, you can actually not even getting the documents and all, you can go in person and inspect. That is also done by most of the RTI activists. Okay, inspection of the work, document records, taking notes from there, extracts from there, getting certified copies, you can do that, or taking any separate samples if it is some material, obtaining informations even in a floppy disk, tapes, pen drives, or something like that in any electronic mode. You can do that. Okay, now how do who has this right? Yes, right to information is there, and one person comes from German, other person comes from Russia, and goes to a department in India and asking for maybe our PMO office and ask certain information. Whether the PMO office must give? No, they can't. They need not give. So who has this particular right to information? Section 3 says that all citizens only have the right to information. You must be a citizen to enjoy the benefit of this act. Okay. And I will ask an information and you can give me after 2 years. See, right to information is there. You can ask, but I will not answer. I will answer only after 2 years. Then what is the use of this act? That's why we have section 7 giving a time frame. It says that you give expeditiously as possible. Within 30 days, you give. And if any information is related to the life and limb problem, which is directly related to your Article 21, then you have to answer within 48 hours. We had an RTI related to life and limb problem because in children's hospital there was one there was few emergency units which did not have proper equipments. Because of the failure of this equipments, there were very just born babies were dying in Chennai actually, Egmore. Okay, so from our office we had put an RTI and they did not reply actually, and we went higher and higher and we got the equipments done ready. But As the time we went and we got everything done, at least some 9 to 8 babies died. It is one of the saddest part of my life, but at least we had something, right? We are able to save others. That's what I thought. Now, okay. So if it is something related to life and limb, within 48 hours, we should get the reply. Okay. Now, what is the procedure? It is given under section 6. We will see what is section 6. Now, see, you want pizza for tonight, maybe like that. And you go to your mother and ask for pizza. I don't think any mother would do pizza at home unless and until she's a Gen Z mom or a young mother or something like that. If I go and ask my mother pizza, she will give me a smack and says that no, there is dosa, idli, chapati. You eat, that is only good for health. Don't talk about carbs to me. Whenever we open the mouth and talk like it is all carbs, they are getting irritated. What is carbs? We ate only this and it is very good for health. What is protein you are running like that. Okay, so if you want an information, what must be done? That information must be saved. If you want a pizza, that must be done, then only it can be brought to you. Like that, your right to information, that corresponding right will have a corresponding duty. Okay, this right will have a corresponding duty. You have the right to information, and the government officers are having a corresponding duty to maintain the information. You ask some information like how many FIRs are registered in this particular district. The public officer will say, I don't know, I don't have the record. If at all this section is not there, they will say, because they may not have an obligation. So section 41 clause B says that the government has to maintain a proactive basis. They have to maintain all the data so that the citizens can enjoy the right to information. So the right to information is having a corresponding duty as well. And this is not only given in our domestic act, it is also given in the UN principle of freedom of information 2000. It says that there is an obligation on all the public to disclose the information, and every member of the public has a corresponding right to receive information. That is an obligation to disclose. The public bodies has an obligation to disclose it, which means they have to maintain it, and correspondingly we have the right. So right and duty are correlated. Okay, next we are talking about information, whether seeking all information is good, giving all the information is good. Yes, I am a good person. Whether I can give all my private details, no, that cannot be given. Like that, government also, there are certain details which shall not be revealed. So that's why we have section 8, which says that your information on this area is exempted from disclosure. We cannot give any information if it is falls under section 8. Okay, that is given here. And you need a person to pin the responsibility. Every department should give the information. But who is the person that will be doing this work? That's why section 5 says every department must appoint an public information officer. And we have an APIO who is an assistant public information officer. They must be designated. So we will be addressing our RTI like this: to PIO concerned department, if it is railways or something, if it is secretariat, if it is high court or supreme court, there will be designated PI. So okay, to him you will be sending. And how do you send it? We have a right to information application. We don't have specific formats, but you can apply right to information, seek right to information under section 6. Okay, that you have to mention. And what is the time frame? It is given under section 7. Okay, all these sections are very, very important. Any question appears, you have to mention definition, public authorities, and what is right to information, to whom it is given, and what is the time period, the procedure, and the corresponding duty on the officials, and where the information is exempted, section 8. All this you have to mention. Now, coming to section 8, non-disclosures. What I will not disclose to you is anything which is going to affect the sovereignty and integrity of India. Especially, we all know, see, the statehood, that is Indian, you have that thing as an Indian, right? That is non-negotiable. Patriotism is non-negotiable. Okay, like that, sovereignty and integrity of India cannot be compromised. Next, anything expressly forbidden by the court of law. Today I put an RTA and asked that what is the upcoming UPSC prelims question paper and upcoming UPSC mains question paper. If that can be done, it will be nice, right? But our hearts should not race for this because you're all very good public servants. So you will not look for this, right? So anything which is expressly forbidden by court of law, we cannot ask that. And anything that is going to breach the privilege of your legislature and parliament, you cannot ask that, which is protected under the constitution. Next, I am looking to launch a competitor to Coca-Cola. So I want the formula of Coca-Cola. That is the most protected trade secret. It's the longest protected one. Okay. So I can get an information from the government or any food safety and all. You are inspecting Coca-Cola. So tell me what are the ingredients of Coca-Cola. That is given at the back. But what is the combination formula and all those things? Trade secrets cannot be asked, including intellectual property. And then any person is protecting the information in fiduciary relationship, you cannot ask. That is even protected under your Indian Evidence Act and BSA. Okay. And next, a confidence from the foreign government, you cannot ask. And anything that would endanger the life and physical safety of a person, you cannot ask. And impede the process of investigation. That's why we got this victim protection scheme and all. Okay, so anything if you say that is going to stop the investigation in any case, then that cannot be asked. And any information relating to personal things, which is unwarranted invasion of privacy. In Pavan Kumar case law, what happened? It was some income tax thing, okay, and they put an RTI asking the disclosing the economic status of wife. So you're proceeding against the husband. Yes, you can say the income tax can go and search the wife's wealth and even related person's wealth and all. It can be done. But if a third party is asking to disclose the wife's property and all, that is invasion of privacy. So okay, that was dealt in. And then we have J, which says that any infringement of copyright you cannot ask. Say, for example, they want a copy of the manuscript, the parent book of something like DD Basu's book. You have a version, that's okay. But Basu is going to publish another law book. And before it is published, you are asking for the manuscript of the book. That cannot be done. Okay. And we have a new addition, 8 clause 1 clause J, which is the recent addition, but it was done in 2023, but it is the recent one. Okay, 2023, because of the Digital Personal Data Protection Act of 2023. It told that any personal information in digital form cannot be given unless and until the authority feels that it is for the larger public interest. Okay, so this 8 clause 1 clause J and RTI Act, comparing digital personal data protection and RTI Act, there may be a question. So you have to know about this. Okay, just research a little bit and keep that's enough. Okay, next. So anything a public authority feels that it is going to affect a person, he cannot give the information unless and until the public good outweighs it. So you have an individual right and the public good, and the public good is more right there, and the privacy can be breached for the public good, then that can be done by the authority. Okay, that liberty is also given. So what all is protected here is important. It's a previous year question. Now, coming to the next point, I have a 2020 question which says that discuss the rationale of exemption to disclose information endangering the life and the information regarding criminal trial and criminal investigation provided under the RTI Act. So here you have to link uh, anything regarding the investigation. You have certain clauses, right? So what all information is protected under the 8, especially which is like endangering someone's life. or regarding any criminal trial. So which clauses are important? Clause G is important. Information that would endanger anyone's life cannot be given, and information which is going to impede the process of investigation cannot be given. That you have to mention first. So you first start with how RTI is important, transparency and all those stuff. Although we have the right to information for the in this section 6, and we have this can be sought by citizen under section 3, and the public authorities having a corresponding obligation under particular section and all you mention, and say that still it cannot invade something given under section 8, and especially the clause G, and you have the next clause which is H, and you explain the clauses and supplement your answer with two important case laws. In this case laws, what happened? They will ask information regarding the evaluators of the examination. Actually, it is the Bihar Public Service examination, and also some examination they will file an RTA and ask who are going to be the evaluators. Okay, so if the evaluators' names are given out, what can happen? People can go and coerce the person. That's what given in the case law itself. It says that if the name is given, he cannot perform his duty properly. If the personal information is given, personal safety of the person will be at stake. You can kidnap his or her daughter and say that you have to pass me award so much marks, then only I will send your daughter back. Okay, that can be done. So all these things were given in this particular case law. So you have to mention the case laws also. And investigation also cannot be done. Mere pendency. See, actually, mere pendency of the investigation will not stop it. Just because the investigation is right there and you ask something, the official cannot say, see, investigation is pending, I won't give you information. No, not like that. He must prove that if such information is given, the investigation will be at stake. Some problem will come. Okay, so like that, you given some illustration and also support it with the witness protection scheme. We have this witness protection scheme which was brought in 2018, but it was recognized. We had that scheme only as a small scheme provided by the government, but it was statutorily recognized by our BNSS. Okay, Bharatiya Nagrik Suraksha Sanhita. There we have a separate section added for witness protection scheme. We have another scheme called as victim protection scheme. Don't confuse yourself. It is witness protection scheme. So in case you are going to give information, that is a witness, being a witness for a murder trial, even I will say I will be afraid. He is able to murder someone, and if I give a witness, won't he at least break my mouth? He will definitely do it. So I will be afraid only. Okay. So naturally, that's what is reality. So what government thought of it? It will protect my identity. It will help me to stay in some other place. It will help me change my address or something, all those things. It will try to protect my identity as far as possible. Okay, that's what is witness protection scheme. So you can link that as well with this section. Okay. So now coming to the next important area, talking about the appeal mechanism. You say we have right to information, public authority must maintain, I will go get the information. But if they don't give, what I can do? I have two-tier mechanism for appeal. I can do a first appeal, and if I'm not satisfied still, I can go for a second appeal. So, in what basis I can go for an appeal and all? We have section 19. It says that no information received. I keep asking and you keep being quiet. How do I receive the information? I didn't receive any information. That is one thing. And aggrieved by the information given by PIO. There are certain offices where they will put nil for everything. We ask something very legit and they will say that not applicable, nil, like that they will put. Okay, so if you are aggrieved by the information of the PIO, you can go for an appeal. So the first appeal will be the senior officer to the PIO, so that you can go after the expiry of 30 days from the prescribed time. Okay, so some 30 days is over. Within 30 days, they must provide the information. So 30 days is over, and you file it within this time frame. That is from the end of this 30 days, within another 30 days. Say for example, 1st of January is my 30 days expiring. Then within what time I must file the first appeal? Within the 1st of Feb. So 30 days I have time within which I have to file the first appeal. And they give something which I'm not still, sorry, which I'm not still okay. What I can do, I can go to the commission for the second appeal. So the first appeal is within the department. You go to the public information officer, is not giving any information properly, go to the senior officer. That is your first appeal. And next thing, next appeal, that is your second appeal, crosses the department and goes to the commission, which was lacking in the Freedom of Information Act. Okay. So second appeal, you go to the central or state commission. Within 90 days of the decision, you can file this appeal and go there. Okay. So what is the penalty? We know that this person must give the information. He is not giving the information. He must be given some penalty. That's what given under section 20. It says that for every erring day, for per day, they can charge you 250 rupees. So supposedly within 30 days, you must give the information and there is 5 days delay. So 5 into 250, that will be your penalty. And there are people who keep the application for even a year. So if you put 250 and all for 3 years, 4 years, it will go for lakhs and all, right? So whether you can put penalty in lakhs, no. So per day 250, but it cannot exceed 25,000. Okay, that is the limit. Next, whether the courts can entertain any suits against these, any complaints against these PIOs, no, they are prohibited. You do the first appeal in the department, second appeal in the commission, then you go to the central commission, and after the central commission, you go only to the Supreme Court. Okay, if you have the state commission, you can directly go to the high court. Like that, you can go. But lower courts cannot entertain, are barred from entertaining any applications. But you have Article 32 and 226, which cannot be barred. So, something very serious. They are not informing. Because of that, many people are dying. You can approach Article 32, 226. That can be done. Okay. So now coming to an important case law, we all saw about the penalty, which is so much rupees. But in this interesting case law, the State Information Commission in Karnataka, where the information was not given, the compliance was not done, the orders compliance was not done for 2 years. So they issued an arrest warrant. It is the first case law where for default in an RTA Act, arrest warrant was issued. Okay, this you can quote. Now, these things and all, yeah, whatever I explained, the reason for appeal that is given here, you can read it once again. Now, we were talking about commission. Now, what is the constitution of the commission? Central Information Commission is given under section 12 and State Information Commission is given under section 15. So, the Central Information Commission will be headed by the Chief Information Commissioner, CIC, and he will be appointed by the President. And what will be the State Information Commissioner? He will be appointed by the governor. Same like that. Okay. So, when we can see, if a PIO doesn't give any information, you can go and appeal. And you can go for a complaint as well. Appeal is under 19 and complaint is given under section 18. So I didn't mention the section, please note it there, because we do give the complaint again and again. That's why. Okay. So on what basis you can go for the complaint? That is, PIO has not been appointed itself. As per section 5, every department must designate an officer as PIO. Now the department will say, see, we don't have a PIO. We did not designate. How you will get the information? If they are so clever, then we can put a complaint against them. Okay. Next, refuses to give some information and received no response from them, or they charge the fees for getting information which is unreasonable. Say, for example, what is the fees we must pay for this RTI is 10 rupees. It is not that you have to stick the note and send. You can give it as a demand draft. You can stick court fees stamp and you can send. Okay. Like that, if we send, that fees is for the reply only. So, say for example, I wanted to get the information of how many percent of UPSC law optional aspirants clear or something like that, pass percentage or something like. I'm planning to put one, okay, because they are not publishing it anywhere. And the latest report is in 2017. Now it is 2024, 2025, going to be 2026. Still, there is no clear data on UPSC options, how much they, how much pass percentage is there, and all those stuff. It is not available, right? I want to check again with you people whether it is available recent. If we ask to get the data printed, for that printing cost, they will give a reply. You have to pay so much, 200 rupees or 10 rupees or something like that. Okay. If they are asking the reasonable cost, we can pay. And if they are asking some 5,000 for 5 sites, or they are very pissed off because you are asking the information which is protected, so they can ask some 25,000 to give this information. What happens? They are preventing us from getting the information, right? So unreasonable. If the fees charged for getting the information is unreasonable, also we can file a complaint. Okay. And next, there are certain areas where they will give the information, but only half information, incomplete information. So they'll be in this area like, see, I only gave the information, right? You cannot put a case against me. You cannot put a complaint against me. No. If it is an incomplete information, if it is a misleading information, if it is a false information also, we can file complaint. Okay. And this commission will have the power of the civil court, which is again we are repeating, summoning power, enforcing the attendance of the person, compelling to give evidence, producing documents, requiring discovery and inspection of the documents, getting evidences from affidavits, and asking for public records, issuing summons, everything it can do. Okay, so it has the power of the civil court. Now, coming to an important area which is repeatedly asked, that is salient features of the RTI Act. Okay, so it cannot be common ones that everyone say. When you come to salient features, try to give the salient features and link it. You're able to hear me, right? There's a lot of crackers here. I don't know why. Anything special today? They are bursting crackers and all.
Ma'am, it's Kartike Deepam.
Kartike Devam. Ayo, right, right. If I ask this to my mother, she'll be like agitated. See, you didn't do anything at home. Okay, fine. I'm doing something makes me happy. Okay. So now coming to the salient features, you have to give the salient feature and also quote the section, which is very, very important. Okay. First thing, maximum disclosure principle. If you see the RTI Act, what is the definition of information? Any material in any form. You see the inclusive the thing it holds. So it is maximum disclosure principle. Most of the information can be accessed. So information, any information held by the public authority, all are accessible. It is an inclusive definition. So it follows what principle? Maximum disclosure principle. Here you can give section 6 as relevance, and also section 2 clause J, which defines your information, 2 clause I and 2 clause J also. Okay. Next, coming to next point, it is limited scope on non-disclosure. If you see section 8 points out everything. Only which is pointed out, information cannot be sought. If it is pointed out, it means others can be given, right? So it is like limited scope for non-disclosure. Only these things are protected. Others, you can ask like that. Okay. Next, adequate appellate mechanism. Yes, we have double appeal. You have your first appeal, you have your second appeal. So we have an adequate appellate mechanism. Okay. And next, there is a nominal fee charge. It is not even 100 rupees. You can tell like, ma'am, 100 rupees is nominal only. There are certain areas in India, even in Tamil Nadu, you go to Bihar, you go to Sikkim, somewhere, anywhere, 100 rupees is very hard to earn. Okay. 10 rupees is a kind of nominal. Okay. So nominal fees only is charged to seek information. Next, strict time limit. Why do you have the schedules? Like you make a plan to read, right? Today I am finishing this part of prelims. Today I am finishing this part of UPSC law optional. Why do you have it? You have some time frame for you. You complete it within that, right? Like that, here also we have strict time limit. Whether you are complying with that, completing within the timetable, that's a different question. That also applies here. Whether within 30 days they are giving, mostly they won't give. But nowadays, fearing the appeal and all, something they would give within 30 days. Okay. So there is a strict time limit, 30 days is given. And protection of whistleblowers. I told you, right? There is a clause in this section in RTI says that any disclosure made, PIO is not responsible unless and until it is very much protected and he is affecting the Official Secrecy Act. Unless and until that, any information he gives, he cannot be sued. Any departmental action cannot be taken against him. Say for example, he is a doctor working in a government hospital and he is a designated PIO. We are putting an RTA asking how much oxygen cylinders were present or something like that, and he says that we did not purchase oxygen for the last 2 months. And we ask the question, next question, how many people died because of shortage of oxygen? He gives the number, some 15 died, something like that. And the senior comes in and says that you have done something wrong and all, and we are putting a departmental action against you because of this RTA. That cannot be done. Okay, so any disclosure made, the PIO will not be responsible. Okay, so all these things are features of the RTA. You can have a question whether RTA alone talks about right to information. No, we have Representation of People's Act, which says that criminal antecedents of the electoral candidates must be disclosed. That is a one good thing. Okay, whatever FIR, everything. Nowadays, it has become a medal. See how many FIRs I'm having against me. You see, there will be a huge list. Okay, even for advocates, nowadays it has become a medal. If you have a lot of criminal cases, you are an active advocate. That any case can be brought before you. You don't even go to the court. You can solve it between yourselves. Okay, so criminal antecedent disclosure. That's also information that was given in Representation of People Act. We have Section 87 of the Semiconductors Act asking you to disclose the information. We have Section 18 of the Designs Act also asking you to disclose certain designs. Okay, so all these things are added marks, added points that you can get. And now coming, we all spoke about information. You give the information, you give the information, you give the information. But once I am giving the information, I will be killed because that information is against the government. Who will protect me? For that, we have the less effective act, which is the Whistleblowers Protection Act of 2011. I should say that we can, so once your name is out, it's very difficult to stay safe. Even an IAS officer called as Sahayam IAS, right? He gave a very big report about a very big scam which happened in Tamil Nadu. But whether he was able to come and give evidence in the court, he's the person who exposed it, but he was not able to come to the court to give the evidence. Okay, so Whistleblowers Act protects him, but still he was not able to. Okay, just for writing sake, you can use this act for the answer. And we all know a lot of RTA activists were killed. Rajendra Prasad Singh, he was an active person in RTI. He was in Bihar actually. He revealed a lot of unethical activities of the local government and all, healthcare and all, and he was killed. Okay. And if you put, he was shot dead, I guess. And Amit Jetwa, he was also an RTA activist. He was putting RTA to stop and reveal the illicit mining in Gujarat. A lot of money comes from mining. And if it is South India and if it is a river basin and all, you have a lot of illegal sand mining. Okay. Sand theft is very common. So if you're putting a lot of RTA and stopping it, horrific death has occurred. Okay. I'm not like, see, people, I'm not putting any negative thing in your mind, but this is what is happening. As a civil servant in your answer, it should not only reflect knowledge, It should also reflect what happens in current scenario. Okay, so do mention these things if possible. Okay, that is important. Negative thing about the RTA Act, very active. You're going to dig up something, it becomes negative for some people. Okay, and also, what are the negatives about RTA Act? Can you tell something? What is the negative thing about the RTA Act? Challenges the RTA Act face. Each person tell one thing. Balasa, can you tell something? Some challenge associated with RTA Act? If you don't know, you can say don't. Okay.
Uh, it may take a long time to process the
Long time.
uh,
Yes.
queries.
Sometimes it gets long time. Right. Okay. Teja, sir.
Some frivolous RTIs, ma'am, for personal gains.
Frivolous. Right. For personal gain, that is the first thing. You see, there is a lot of misuse of law and harassment of the public authorities. You don't like that public authority who is straight and who doesn't get any corruption and all, who's not favoring you. What you will do? You will be desperately asking voluminous information. You will put a lot of RTI that he is not able to do his public work. Okay. And for attaining publicity, use RTI like pill. Okay. And then for vindictive tool to harass them, to pressurize them, you use RTA. I have actually seen a case where a person put in RTA. Actually, he's the brother of that authority. This brother's fight sometimes it goes to the extent of killing also. Okay, the brother has put in RTA to the officer asking that what was your antecedent in criminal thing or something like that, and he knows something he has done wrong in the office or something like that. So he was asking like that, what is the accounts you did last year, something like that, to trap him. Okay, like that, a vindictive tool, it can be used. And next, illiteracy and unawareness. Majority of Indian people, sad to say, but I'm sure that we will reach our literacy rate soon. So majority doesn't know about RTI. If you don't know the tool exists, how you're going to use it? So that was one challenge. Nandita, can you tell about any other challenge?
Ma'am, there are cases where some information might be a threat to the national security.
That is not a challenge, okay? That shall not be given for our benefit only. So some challenge. Because of it, RTI is not working well. Something like that.
Red tapeism.
Red tapeism. Oh, yeah. Red tapeism is also one reason. Okay. And next, certain people will use RTA as a grievance redressal. If your street lights are not working, what you must do? You write a representation to a municipality telling that, see, my street light is not working or something like that. You put a representation. But what an advocate will do, even I will do this because you do something and you get the things redressed. That's what I will prefer, right? So instead of putting a representation, I will put a letter to the concerned authority, RTA concerned authority, telling that, see, when is the last date you have repaired these lights, street lights, and how long it is not working. If it is not working properly, who is the authority who can be penalized, who will be responsible for this? And final question, who is the appellate authority to whom I can complain this particular authority? Or if you don't answer, to whom I can put an appeal? I will ask this in the question. Once I ask this, immediately they will come and do something to redress it. Okay. So RTA is get the information, but certain people aim to use it as a grievance redressal mechanism, which is again a problem for RTA, it seems. Okay, but still, I'm using it. Okay, now coming to the next point, poor record keeping by the bureaucrats. You ask the information, but I did not compile the information. What you will do? See, nowadays also a lot of JMs and officers, they have been asking, like, the High Court and the Supreme Court will have a lot of records, ask a lot of records from the lower courts. The person will be appointed only 3 years you can be in that particular court. Okay. So for past 3 years they will have the record, but the judge who was there before 10 years will not maintain the same, where they will go for the records. So that happens a lot of time. Poor maintaining of records. You can ask, I don't have the record. I'm here only for 1 year. The past 5 year, 10 year, 15 year, nobody maintained. What I will do? That happens. Okay. Then lack of staffing. Information commissions will run only when they have fund and also they have proper staff. I will say that our police mechanisms, police stations does not have enough people. Really, they don't have enough people. See, I heard that yesterday we wanted to give a complaint for my client or something in the police station. We went there. There was only two people. They were struggling with everything. I'm not supporting police or something. There are good and bad people everywhere, but there are only two people, and they were not able to get enough things done there. When we asked where are the other people and all, they immediately told they went for Tiruvannamalai Karthikey Deepam thing. Now I remember to control the crowd. If they don't go there, there'll be a stampede. Everyone went there from entire state. You see, Tiruvannamalai is somewhere in Tamil Nadu. An entire state people, even from Chennai, officers are going there. Lack of officers. They will say we have reserve police force, which is not enough again. Like that. There is lack of staffing, even in information commission. And there are areas where government will not proactively publish information. There are a lot of mandates in government departments to publish certain information. We know in official gazette all the notifications must be published. Whether we can easily access the official gazette in internet, you put the official gazette, whether everything comes out, certain GOs and all, it is very hard to get for our cases. We go to the concerned department, we ask the person, we follow them, whether it will not be uploaded in the internet. Even judgments must be uploaded in the e-courts, right? They will upload after 2 weeks because they don't have enough staffing. And FIRs also must be uploaded. They will say, but whether you can get any FIR online, it will be very difficult. It depends upon the department. Okay. So the government does not publish most of the information in the public domain, which they must publish as per the government mandate. Since they are not publishing what people are pushed to do, they must file an RTA. So the number of RTAs are increasing. And there is red tapeism. Okay, that is one more thing. And frivolous RTI. It is happy to send a lot of frivolous things, right? The government officials are torturing us. Why don't we torture them back? We will put frivolous RTIs. That is also done here. So these are the negative things about RTI. And also, I have brought about the Right to Information Act. You have this why it is brought out. Okay, so do read after the class. After this, we have few more informations, which is talking about 2019 amendment, only little, and also about the longest case which happened from 2010 to 2020. How political parties can be brought under the purview of RTA. All these things are irrelevant since we came to 2025. When I was taking class in 2019 and all, it is important. But now it is not important. But if you find time, do read the last 3 slides. You can get some info. That's all. Okay. Otherwise, we have completed today's class. Any doubts, you can ask me. Any doubts? Tomorrow? Yes, sir. Please tell me.
No, ma'am, no doubts. I was
No doubts.
saying no doubts.
Okay. So tomorrow, please do take the test. We will be starting with law of contracts. We will complete it soon. And then we will be completing constitutional law, international law. And probably by the end of January, we'll be completing the entire portions. Okay. Max it goes to half of Feb. We will be completing everything. All the very best. Thank you.
Thank you, ma'am.
Thank you.
Thank you, ma'am.
Thank you, Nandita.